Hi all, welcome to the A-Level Law Essay channel. In this episode, I'll be covering a past year papers question 6 from 9084/31 paper 3 Law of Contract October-November 2018. Please note that this video tutorial is a 3-part series. This being part 3, I will only be going through with you the essay sample to answer the question. If you have not watched the video reviewing this question and its marking scheme, it is recommended that you do so before continuing with this video. You may click on the card above or the link in the description below this video to check out part 1 past year paper question review for this question. Before I begin, please subscribe to my channel for more video guides on essay writing and many other interesting topics. With that said, let's get started with part 3 essay sample of video tutorial number 13. Question. The question reads, Elsa, Faith and Georgie are members of a dance band. They have just finished playing at a wedding when Elsa is approached by her uncle Harry, one of the guests, who asks if they would be prepared to play at his daughter's birthday party in August. The members of the band agree to play at the party. At the end of the birthday party in August, Elsa hands a bill for £450 to Harry. He expresses surprise and says he was not expecting to pay for the band. 3 months later, despite repeated requests, Harry has still not paid the bill. Advise Harry and the band of their respective rights and obligations in this situation. 25 marks. To answer a scenario-based problem question, it is important to first identify the relevant parties and the issues that they are having with each other. From the scenario, we know that the disputing parties are Elsa, Faith and Georgie against Harry. Harry, who is Elsa's uncle, asked the band to play at his daughter's birthday party in August, in which the band agreed. Upon completing the gig, the band hands Harry a bill that is due to them to which Harry was not expecting. 3 months have passed and Harry has not paid the bill. Now, we are to advise both Harry and the band as to the legality of the bill that is due. After identifying these important things, we should then be able to figure out which chapter in the contract law syllabus this question is covering. By the looks of some of the key points in the scenario, it is safe to say that it covers the chapter Formation of Contract and that it focuses on the topic intention to create legal relation and consideration, as we have to determine if there even was a valid contract that was formed during the transaction between Harry and the band. Before I begin going through the essay, I would like you to note that my answer is not the perfect essay answer, but it only serves as a guide for you so that you get an idea on how to write your essay and score the highest mark possible for your effort. Incidentally, I may have also left out certain minor details from my content video, as whatever points that have been discussed earlier only serves as a guide for us to reach our end product, which is the essay. One more important thing to note is that since, for examination purposes, the time limit for one essay answer is exactly 30 minutes, I will not have a lot of time to cover every single relevant detail, and the ideal word count for an excellent essay answer is between an average of 700 to 900 words per essay. Introduction. A contract is a legally binding agreement between two or more parties in which mutually agreed obligations are created and can be enforced by law. Because we do not know if there exists a contract between Harry and the band, we first need to consider if a valid contract has been formed as per the common law requirements. Some of the issues that require attention are the requirements of intention and consideration in the formation of contract. Point 1. Body paragraph 1. The most basic requirement for the formation of a valid contract is that one person must have made an offer and another must have accepted that offer unconditionally. However, the problem now relates to the actual contractual offer and acceptance, as we only know that Harry asked the band to play in her daughter's birthday party and the band agreed to it. The question now is whether this transaction equates to a legally binding agreement. Moreover, the issue regarding payment was not even highlighted until after the completion of the gig. and that it apparently didn't even cross Harry's mind that he was supposed to pay the band for the service. Therefore, the real question that should be addressed is whether or not there was any intention to create legal relations when the agreement took place. Point 2. Body paragraph 2. Because people make agreements all the time, it is important to determine if they intend to be legally bound by whatever agreement that they get themselves into before a valid contract is considered to have been formed. In order to determine intention to create legal relation, the courts will assess the parties' intentions objectively and determine if the outward behavior or words used by the parties suggest that they intended to be bound by the agreement. The main determinant is to classify the agreement as either domestic social agreements or commercial agreements. The case of Balfour v. Balfour 1919 shows that a domestic agreement between spouses is usually not considered as legally binding, since by default they are presumed to not have the intention to do so, unless it can be proven that they intend to bargain keenly, as per the case of Merritt v. Merritt 1970. The case of Esso Petroleum Limited v. Customs and Excise Commissioners 1976 shows that commercial agreements are usually between business people or people with business in mind when they deal with each other, and that by default it is presumed that any agreement between these people is considered to be done with intention to create legal relation, unless whatever is said can be considered as a mere puff which holds no legal weight. Point 2. Body paragraph 3. Applying what we know about the requirement of intention into the scenario, the legal outcome can benefit either Harry or the band. Firstly, it is possible to say that it is just a domestic social agreement between Elsa, the band member, and her uncle, Harry, and that it is reasonable to infer that both, or at least Harry, did not intend to be legally bound. This is to say that there isn't any actual meeting of the minds and that the agreement for the payment due isn't mutual. Moreover, it is possible to assume that it was done informally in a social setting rather than a business one. However, on the other hand, if it is common knowledge that the band has been charging people for their performance, then it is possible to assume that both parties, especially Harry, should know that the agreement was a commercial one and that due payment was understood. Point 3. Body paragraph 4. Whether we conclude that the agreement was a domestic social one or commercial one very peculiar thing must be highlighted, i.e., the fact that payment was not even mentioned until the gig was completed. The issue now is with regards to the requirement of consideration. The case of Dunlop v. Selfridge 1915 describes it as something which represents either some benefit to the person making a promise or some detriment to the person to whom the promise is made. One of its important characteristics is that consideration must not be passed, and that we cannot use something that has already been done or given as consideration in exchange for a fresh or new consideration. A good case to illustrate this situation would be Re McArdle 1951, wherein Mrs. McArdle had already performed the work before she asked for payment, and so her consideration was in the past, which is not good consideration. Therefore, agreements made using past consideration is unenforceable. This is exactly what happened in our scenario, where due payment was only mentioned or asked for after the completion of the gig. Point 3. Body paragraph 5. Alternatively, we can also consider the situation in the case of Lumpley v. Brathwaite 1615, where due payment is implied and so therefore consideration satisfied. Applying this to our scenario, we can assume that the performance of the gig was actually provided at the promissor Harry's request, and it was understood that payment would be made in return for the performance of the gig. However, whether or not any of these arguments would stand, we will have to first consider if the courts will conclude that the initial agreement was a domestic social one or a commercial one. Conclusion. Because the question asks us to advise both parties, we cannot really conclude who will win the case if the band were to sue Harry, unless there is conclusive proof that either intention and/or consideration can or cannot be established. But I personally feel that the band should get their payment if they can prove that they have been billing anyone for their performance, including the wedding that they have just performed in. This is the end of the sample essay or the video tutorial. If you have any questions or opinion on my approach to answering the question, please do comment below. Do check out part 2 of this video tutorial for a proper content guide on how to answer this question. I will put a link to it in the description below. If you find this video tutorial useful, please like, share and subscribe to my channel for more. Thank you for watching and I'll see you again next time.